My question wouldn't be why you did resign. My question would be why didn't you resign before?
Folks,
I am going to have to be very careful what I say.
I understand. Do you believe, for the record, that you were removed as the Attorney General because you spoke truth to power on the topic of the SNC ongoing prosecution?
And I will say, it's okay to talk about job losses. It's okay to talk about it in initial conversations. But when those topics continue to be brought up after there's a clear awareness that a decision has been made, it becomes inappropriate.
Chair, I have to say that I am very shaken by what I've heard here today.
I am confident that the purpose of those discussions, the December 18th and December 19th discussions, were to put extraordinary pressure on me to change my mind as to...
we resume our meetings on the study of remediation agreements, the shock cost doctrine, and the discussions between the Office of the Attorney General and government colleagues as relates to SNC-Lavalin. I would very much like to thank our witness today, the Honourable Jody Wilson-Raybould, our colleague from Vancouver-Grenville, who has agreed to come before us today. Thank you so much, Ms. Wilson-Raybould. The floor is yours.
Well, Gaila Kusla, thank you, Mr. Chair, and thank you to the members of the Justice Committee for providing me the opportunity for extended testimony today. I very much appreciate it. And starting off, I would like to acknowledge the territory, the ancestral lands of the Algonquin people. For a period of approximately 4 months between September and December of 2018, I experienced a consistent and sustained effort by many people within the government to seek to politically interfere in the exercise of prosecutorial discretion in my role as the Attorney General of Canada in an inappropriate effort to secure a deferred prosecution agreement with SNC-Lavalin. These events involved 11 people, excluding myself and my political staff, from the Prime Minister's office, the Privy Council office, and the Office of the Minister of Finance. This included in-person conversations, telephone calls, emails, and text messages. There were approximately 10 phone calls and 10 meetings specifically about SNC, and I and/or my staff were a part of these meetings. Within these conversations, there were expressed statements regarding the necessity of interference in the SNC-Lavalin matter, the potential of consequences, and veiled threats if a DPA was not made available to SNC. These conversations culminated in December the 19th of 2018 with a conversation I had with the clerk of the Privy Council, a conversation that I will provide some significant detail on. A few weeks later, on January the 7th, 2019, I was informed by the Prime Minister that I was being shuffled out of the role of Minister of Justice and Attorney General of Canada. For most of these conversations, I made contemporaneous notes, detailed notes, in addition to my clear memory, which I am relying on today, among other documentation. My goal in my testimony is to outline the details of these communications for the committee and indeed all Canadians. However, before doing that, let me make a couple of comments. First, I want to thank Canadians for their patience since the February 7th story, which broke in the Globe and Mail. Thank you as well, specifically to those who have reached out to me across the country. I appreciate the messages and I have read all of them. Secondly, on the role of the Attorney General. The Attorney General exercises prosecutorial discretion as provided for under the Director of Public Prosecutions Act. Generally, this authority is exercised by the Director of Public Prosecutions, but the Attorney General has authority to issue directives to the DPP on specific prosecutions or to take over prosecutions. It is well established that the Attorney General exercises prosecutorial discretion. She or he does so individually and independently. These are not Cabinet decisions. I will say that it is appropriate for Cabinet colleagues to draw to the Attorney General's attention what they see as important policy considerations that are relevant to decisions about how a prosecution will proceed. What is not appropriate is pressing the Attorney General on matters that she or he cannot take into account, such as partisan political considerations, continuing to urge the Attorney General to take her or his mind 4 months after the decision has been made, or suggesting that a collision with the Prime Minister on these matters should be avoided. With that said, the remainder of my testimony will be a detailed and factual delineation of approximately 10 phone calls, 10 in-person meetings, and emails and text messages that were part of an effort to politically interfere regarding the SNC matter for purposes of securing a deferred prosecution. The story begins on September the 4th, 2008. My chief of staff and I were overseas when I was sent a memorandum for the Attorney General pursuant to Section 13 of the Director of Public Prosecutions Act, which was entitled, quote, whether to issue an invitation to negotiate a remediation agreement to SNC-Lavalin, end quote, which was prepared by the Director of Public Prosecutions, Kathleen Roussel. The only parts of this note that I will disclose are as follows. Quote, the DPP is of the view that an invitation to negotiate will not be made in this case and that no announcement will be made by the PPSC, end quote. As with all Section 13 notices, the Director provides the information so that the Attorney General can take such course of action as they deem appropriate. In other words, the Director had made her decision to not negotiate a remediation agreement with SNC-Lavalin. I subsequently spoke to my minister's office staff about the decision, and I did the standard practice of undertaking further internal work and due diligence in relation to this note, a practice that I have had for many of the Section 13 notices that I received when I was the Attorney General. In other words, I immediately put in motion with my department and minister's office a careful consideration and study of the matter. 2 days later, on September the 6th, one of the first communications about the DPA was received from outside of my department. Ben Chin, Minister Morneau's chief of staff, emailed my chief of staff and they arranged to talk. He wanted to talk about SNC and what we could do, if anything, to address this. He said to her, my chief, that if they don't get a DPA, they will leave Montreal, and it's the Quebec election right now, so we can't have that happen. He said that they have a big meeting coming up on Tuesday and that this bad news may go public. This same day, my chief of staff exchanged some emails with my minister's office staff about this, who advised her that the Deputy Attorney General, Nathalie Drouin, was working on something and that my staff were drafting a memo about the role of the Attorney General vis-a-vis the PPSC. It was on or about this day that I requested a one-on-one meeting with the Prime Minister on another matter of urgency, and as soon as possible after I got back into the country. This request would ultimately become the meeting on September the 17th between myself and the Prime Minister that has widely been reported in the media. On September 7th, my Chief of Staff spoke by phone to my then Minister, or Deputy Minister, about the call she had received from Ben Chin, and the Deputy stated that the department is working on this. The Deputy gave my Chief a quick rundown of what she thought some options would be. On the same day, I received a note from my staff on the role of the Attorney General, a note that I also shared with that my office also shared with Elder Marquez and Amy Archer at the PMO. Same day, staff in my office met with the Deputy Minister. Some excerpts of the Section 13 note were read to the Deputy Minister, but the Deputy Minister did not want to be provided with a copy of the Section 13 note. September 8th. My deputy shared the draft note on the role of the Attorney General with my Chief of Staff, who subsequently shared it with me. And over the next day, clarity was sought by my staff with the deputy on aspects of the options that were laid out in her note. A follow-up conversation between Ben Chin and a member of my staff, François Giroux, occurred on September the 11th. Mr. Chin said that SNC had been informed that by the PPSC that it cannot enter into a DPA. And Ben again detailed the reasons why they were told that they were not getting a DPA. Mr. Chin also noted that SNC's legal counsel, Frank Iacobucci, and further detailed what the terms were that SNC was prepared to agree to, stating that they viewed this as part of a negotiation. To be clear, Up to this point, I had not been directly contacted by the Prime Minister, officials in the Prime Minister's office, or the Privy Council office about this matter. With the exception of Mr. Chin's discussions, the focus of communications had been internal to the Department of Justice. This changes on September the 16th. My Chief of Staff had a phone call with Mathieu Bouchard and Elder Marquez from the Prime Minister's office. They wanted to discuss SNC. They told her that SNC had made further submissions to the Crown and that there is some softening, but not much. They said that they understood that the individual Crown prosecutor wants to negotiate an agreement, but the director does not. They said that they understand that they're direct, but that they hear that our Deputy of Justice thinks we can get the PPSC to say, we think that we should get some outside advice on this. They said that they think we should be able to find a more reasonable resolution here. They told her that SNC's next board meeting is on Thursday, which was September the 20th. They also mentioned the Quebec election context. They asked my chief if someone has suggested the outside idea to the PPSC and asked whether or not we were open to this suggestion. They wanted to know if my deputy could do it. In response, my Chief of Staff stressed to them prosecutorial independence and potential concerns about the interference in the independence of the prosecutorial functions. Mr. Bouchard and Mr. Marquez kept telling her that they didn't want to cross any lines, but they asked my Chief of Staff to follow up with me directly on this matter. To be clear, I was fully aware of the conversations between September the 4th and 16th that I have outlined. I had been regularly briefed by my staff from the moment this first arose and had also reviewed all materials that had been produced. Further, my view had also formed at this point. Through the work of my department, my minister's office, and work I conducted on my own, that it was inappropriate for me to intervene in the decision of the Director of Public Prosecutions in this case and to pursue a deferred prosecution agreement. In the course of reaching this view, I discussed the matter on a number of occasions with my then deputy so that she was aware of my view, raised concerns on a number of occasions with my deputy minister about the appropriateness of communications we were receiving from outside the department, and also raised concerns about some of the options that she had been suggesting. On September 17th, the Deputy Minister said that Finance had told her that they wanted to make sure that Kathleen understands the impact if we do nothing in this case. Given the potential concerns raised by this conversation, I discussed this later with my deputy. This same day, September 17th, I have my one-on-one meeting with the Prime Minister that I requested a couple of weeks ago. When I walked in, the Clerk of the Privy Council was in attendance as well. While the meeting was not about the issue of SNC and DPAs, the Prime Minister raised the issue immediately. The Prime Minister asked me to help out, to find a solution here for SNC, citing that if there is no DPA, there would be many jobs lost and that SNC would move from Montreal. In response, I explained to him the law and what I have the ability to do and not do under the Director of Public Prosecutions Act around issuing directives or assuming conduct of prosecutions. I told him that I had done my due diligence and had made up my mind on SNC and that I was not going to interfere with the decision of the Director. In response, the Prime Minister reiterated his concerns. I then explained how this came about and that I had received a Section 13 note from the DPP earlier in September and that I had considered the matter very closely. I further stated that I was very clear on my role as the Attorney General and that I am not prepared to issue a directive in this case, that it would not be appropriate. The Prime Minister again cited the potential loss of jobs and SNC moving. Then, to my surprise, the clerk started to make the case for the need for a DPA. He said, quote, "There is a board meeting on Thursday, September the 20th, with stockholders," end quote. quote again, "They will likely be moving to London if this happens, and there is an election in Quebec soon," end quote. At that point, the Prime Minister jumped in, stressing that there is an election in Quebec and that, quote, "I am an MP in Quebec, the member for Papineau," end quote. I was quite taken aback. My response, and I vividly remember this as well, was to ask the Prime Minister a direct question while looking him in the eye. I asked, quote, "Are you politically interfering with my role, my decision as the Attorney General? I would strongly advise against it," end quote. The Prime Minister said, "No, no, no, we just need to find a solution." The clerk then said that he spoke to my deputy and she said that I could speak to the director. I responded by saying, "No, I would not. That would be inappropriate." I further explained to the clerk and the Prime Minister that I had had a conversation with my deputy about options and what my position was on the matter. As a result, I agreed to and undertook to the Prime Minister that I would have a conversation with my deputy and the clerk, but that these conversations would not change my mind. I also said that my staff and my officials are not authorized to speak to the PPSC. And then we finally discussed the issue that I had asked for the meeting in the first place. I left the meeting and immediately debriefed with my staff about what was said with respect to SNC and DPAs. On September 19th, I met with the clerk as I had undertaken to the Prime Minister. The meeting was one-on-one in my office. The clerk brought up job losses and that this is not about the Quebec election or the Prime Minister being a Montreal MP. He said that he has not seen the Section 13 note. The clerk said that he understands that SNC is going back and forth with the DPP and that they want more information. He said that, quote, "Yakabuchi is not a shrinking violet," end quote. He referenced the September 20th date and that they don't have anything from the DPP. He said that the Prime Minister is very concerned about the confines of my role as Attorney General and the Director of Public Prosecutions. He reported that the Prime Minister is very aware of my role as the Attorney General of Canada. I told the clerk again that I instructed my deputy is not to get in touch with the director, and that given my review of the matter, I would not speak to her directly regarding the ADPA. I offered that if SNC were to send, I offered to the clerk, if that SNC were to send me a letter expressing their concerns, their public interest argument, it would be permissible and I would appropriately forward it directly to the Director of Public Prosecutions. Later that day, my Chief of Staff had a phone call with Elder Marquez and Mathieu Bouchard from the Prime Minister's office. They wanted an update on what was going on regarding the DPAs since, quote, "we don't have a ton of time," end quote. She relayed my summary of the meeting with the clerk and the Prime Minister. Mathieu and Elder also raised the idea of a, quote, "informal reach out," end quote, to the DPP. My Chief of Staff said that she knew I was not comfortable with that, as it looked like and probably did constitute political interference. They asked whether that was true if it wasn't the Attorney General herself, but if it was her staff or the Deputy Minister. My Chief of Staff said yes, it would, and offered a call with me directly. They said that they will regroup and get back to you on that. Still on September the 19th, I spoke to Minister Morneau on this matter when we were in the House. He again stressed the need to save jobs, and I told him that engagements from his office to mine on SNC had to stop, that they were inappropriate. They did not stop. On September the 20th, my Chief of Staff had phone calls with Mr. Chin and Justin Toh, both members of the Minister of Finance's office, about DPAs and SNC. At this point, after September the 20th, there was an apparent pause in communicating with myself or my Chief of Staff on the SNC matter. We did not hear from anyone again until October the 18th, when Mathieu Bouchard called my Chief of Staff and asked that I look at the option of seeking an external legal opinion on the DPP's decision not to extend an invitation to negotiate a DPA. This would become a recurring theme for some time in messages from the PMO that an external review should be done of the DPP's decision. The next day as well, SNC filed a federal court application seeking to quash the DPP's decision to not enter into a remediation agreement with them. In my view, this necessarily put to rest any notion that I might speak to or intervene with the DPP or that external review could take place. The matter was now before the courts and a judge was being asked to look at the DPP's discretion. However, on October the 26th, 2018, when my chief of staff spoke to Mathieu Bouchard and communicated to him now that given that SNC has now filed in federal court seeking to review the DPP's decision, surely we had moved past the idea of the Attorney General intervening or getting an opinion on the same question. Mathieu replied that he was still interested in an external legal opinion idea. Could she not get an external legal opinion on whether the DPP had exercised their discretion properly? And then, on the application itself, the Attorney General could intervene, seek to stay the proceedings, given that she was awaiting a legal opinion. My chief of staff said that this would obviously be perceived as interference and her boss questioning the DPP's decision. Mathieu said that if 6 months from the election, SNC announces they're moving their headquarters out of Canada, that is bad. He said, quote, we can have the best policy in the world, but we need to get reelected, end quote. He said that everybody knows that this is the Attorney General's decision, but that he wants to make sure that all options are being canvassed. Mathieu said that if, at the end of the day, the Attorney General is not comfortable, that is fine. He just doesn't want any doors to be closed. Jessica, my chief of staff, said that I was always happy to speak to him should he wish. In mid-November, the PMO requested that I meet with Mathieu Bouchard and Elder Marquez to discuss the matter, which I did on November 22nd. This meeting was quite long. I would say about an hour and a half. I was irritated by having to have the meeting as I had already told the Prime Minister, etc., that a DPA on SNC was not going to happen, that I was not going to issue a directive. Mathieu in this meeting did most of the talking. He was trying to tell me that there were options and that I needed to find a solution. I took them through the DPP Act, Section 15, Section 10, and talked about the prosecutorial independence as a constitutional principle, and that they were interfering. I talked about the Section 13 note, which they said they had never received, but I reminded them that we sent it to them in September. Mathieu and Elder continued to plead their case, talking about if I'm not sure in my decision that we could hire an eminent person to advise me. They were kicking the tires. I said no. My mind had been made up and they needed to stop. This was enough. I will briefly pause at this moment to comment on my own state of mind. In my role as Attorney General, I had received the decision of the DPP in September, had reviewed the matter, made a decision on what was appropriate given a DPA, and communicated that to the Prime Minister. I had also taken additional steps that the Prime Minister asked me to, such as meeting with the clerk. In my view, the communications and efforts to change my mind on this matter should have stopped. Various officials also urged me to take partisan political considerations into account, which it was clearly improper for me to do so. We either have a system that is based on the rule of law, the independence of prosecutorial functions, and respect for those charged to use their discretion and powers in a particular way, or we do not. While in our system of government, policy-oriented discussion amongst people at early points in this conversation may be appropriate. the consistent and enduring efforts, even in the face of judicial proceedings on the same matter, and in the face of a clear decision of the Director of Public Prosecutions and the Attorney General to continue and even intensify such efforts, raises serious red flags in my view. Yet, this is what continued to happen. On December the 5th of 2018, I met with Jerry Butts. We had both sought out this meeting. I wanted to speak about a number of things, including bringing up SNC and the barrage of people hounding me and my staff. Towards the end of our meeting, which was in the Chateau Laurier, I raised how I needed everybody to stop talking to me about SNC, as I had made up my mind and the engagements were inappropriate. Jerry then took over the conversation and said how we need a solution on the SNC stuff. He said I needed to find a solution. I said no, and I referenced the preliminary inquiry and the judicial review. I said further that I gave the clerk the only appropriate solution that could have happened, and that was the letter idea that was not taken up. Jerry talked to me about how the statute was a statute passed by Harper and that he does not like the law. I said something like, that is the law that we have. On December the 7th, I received a letter from the Prime Minister dated December 6th, attaching a letter from the CEO of SNC-Lavalin dated October the 15th. I responded to the Prime Minister's letter on December 6th, noting that the matter is before the court, so I cannot comment on it, and that the decision re a DPA was one for the DPP, which is independent of my office. This brings me to the final events in the chronology, the ones that signal, in my experience, the final escalation in efforts by the Prime Minister's office to interfere in this matter. On December 18th of 2018, my Chief of Staff was urgently summoned to a meeting with Jerry Butts and Katie Telford to discuss SNC. They wanted to know where I am at in terms of finding a solution. They told her that they felt like the issue was getting worse and that I was not doing anything. They referenced a possible call with the Prime Minister and the clerk the next day. I will now read to you a transcript of the most relevant sections of a text conversation between my Chief of Staff and I almost immediately after that meeting. Jessica. Basically, they want a solution, nothing new. They want external counsel retained to give you an opinion on whether you can review the DPP's decision here and whether you should in this case. I told them that would be interference. Jerry said, quote, Jess, there is no solution here that does not involve some interference, end quote. At least they are finally being honest about what they are asking you to do. Don't care about the PPSC's independence. Katie was like, quote, we don't want to debate legalities anymore, end quote. They keep being like, we aren't lawyers, but there has to be some solution here. Mojag, I text. So where were things left? Jessica, so unclear. I said would of course let you know about the conversation, and they said that they were going to kick the tires with a few people on this tonight. The clerk was waiting outside when I left. But they said that they want to set up a call between you and the Prime Minister and the clerk tomorrow. I said that of course you'd be happy to speak to your boss. They seem quite keen on the idea of you retaining an ex-Supreme Court of Canada judge to get advice on this. Katie Telford thinks it gives us cover in the business community and the legal community, and that it would allow the Prime Minister to say we were doing something. She was like, quote, if Jody is nervous, we would, of course, line up all kinds of people to write op-eds saying that what she is doing is proper, end quote. On December the 19th, 2018, I was asked to have a call with the clerk. It was a fairly lengthy call, and I took the call from home, and I was on my own, by myself. Given what occurred the previous day with my Chief of Staff, I was determined to end all interference and conversations about this matter once and for all. Here is part of what the clerk and I discussed. The clerk said he was calling about DPAs, SNC. He said he wanted to pass on where the Prime Minister is at. He spoke about the company's board and the possibility of them selling out to someone else, moving their headquarters, and job losses. He said that the Prime Minister wants to be able to say that he has tried everything he can within the legitimate toolbox. The clerk said that the Prime Minister is quite determined, quite firm, but he wants to know why the DPA route, which Parliament provided for, isn't being used. He said, quote, "I think he is going to find a way to get it done, one way or another." So he is in that kind of mood, and I wanted you to be aware of it, end quote. The clerk said he didn't know if the Prime Minister was planning on calling me directly or if he is thinking about getting somebody else to give him some advice. You know, he does not want to do anything outside of the box of what is legal or proper. He said that the Prime Minister wants to understand more, to give him advice on this or give you advice on this if you want to feel more comfortable you are not doing anything inappropriate or outside the frame. I told the clerk that I was 100% confident that I was doing nothing inappropriate. I again reiterated my confidence in where I am in my views on SNC and the DPA have not changed. I reiterate this is a constitutional principle of prosecutorial independence. I warned the clerk in this meeting that he was in this call that we were treading on dangerous ground here. I also issued a stern warning because as the Attorney General, I cannot act in a manner, and the prosecution cannot act in a manner that is not objective, that isn't independent. I cannot act in a partisan way, and I cannot be politically motivated. This all screams of that. The clerk wondered whether anyone could speak to the director about the context around this or get her to explain her reasonings. The clerk told me that he was going to have to report back to the Prime Minister before he leaves. He said again that the Prime Minister was in a pretty firm frame of mind about this, and that he was a bit worried. I asked what he's worried about. The clerk then made the comment about how it is not good for the Prime Minister and his Attorney General to be at loggerheads. I told the clerk that I was giving him my best advice and that if he did not accept that advice, then it is the Prime Minister's prerogative to do what he wants. But I am trying to protect the Prime Minister from political interference or perceived political interference or otherwise. The clerk acknowledged that, but said that the Prime Minister does not have the power to do what he wants. All the tools are in my hands, he said. I said that I was having thoughts of the Saturday night massacre, but that I was confident that I had given the Prime Minister my best advice to protect him and to protect the constitutional principle of prosecutorial independence. The clerk said that he was worried about a collision between the Prime Minister, because the Prime Minister is pretty firm about this. He told me that he had seen the Prime Minister a few hours ago and that this is really important to him. That is essentially where the conversation ended, and I did not hear from the Prime Minister the next day.
I'm just letting everybody know that as chair, I choose to give you more than 30 minutes. You've exceeded it. I'd like you to be able to finish your statement. Is there anybody that has any objection to that? No. Okay, so please continue.
I don't think anyone in the audience does either.
Thank you, Mr. Chair. On January the 7th, I received a call from the Prime Minister and was informed I was being shuffled out of my role as Minister of Justice and Attorney General of Canada. I will not go into details of this call or subsequent communications about the shuffle, but I will say that I stated I believe the reason was because of the SNC matter. They denied this to be the case. On January the 11th, 2019, the Friday before the shuffle, my former deputy minister is called by the clerk and told that the shuffle is happening and that she will be getting a new minister. As part of this conversation, the clerk tells the deputy that one of the first conversations that the new minister will be expected to have with the Prime Minister will be on SNC-Lavalin. In other words, that the new minister will need to be prepared to speak to the Prime Minister on this file. The deputy recounts this to my chief of staff, who tells me about the conversation. My narrative stops here. I must reiterate to the committee my concern outlined in the letter to the chair yesterday. That is, Order in Council number 2019-0105 addresses only my time as the Attorney General of Canada and therefore does nothing to release me from my restrictions that apply to communications while I proudly served as the Minister of Veterans Affairs. And in relation to my resignation from that post or my presentation to Cabinet after I resigned. This time period includes communications on topics that some members of the committee have explored with other witnesses and about which there have been public statements by others. The Order in Council leaves in place the various constraints, in particular Cabinet confidence, that there are on my ability to speak freely on matters that occurred after I left my post as Attorney General. Even with those constraints, I hope that through my narrative today, the committee and everyone across the country who's listening has a clear idea of what I experienced and what I know of who did what and what was communicated. I hope and expect the facts speak for themselves. I imagine Canadians now fully understand that in my view, these events constituted pressure to intervene in a matter and that this pressure or political interference to intervene was not appropriate. However, Canadians can judge this for themselves as we now have the same frame of information. Lastly, as I've said previously, it has always been my view that the Attorney General of Canada must be nonpartisan, more transparent in the principles that are the basis of decisions, and in this respect, always willing to speak truth to power. In saying this, I was reflecting what I understood to be the vital importance of the rule of law and prosecutorial independence in our democracy. My understanding of this has been shaped by some lived experiences. I am, of course, a lawyer. I was a prosecutor in the downtown east side of Vancouver. So I come to this view as a trained professional and committed to certain values as key to our system of order. But my understanding of the rule of law has also been shaped by my experiences as an Indigenous person and as an Indigenous leader. The history of Crown Indigenous relations in this country includes a history of the rule of law not being respected. Indeed, one of the main reasons for the urgent need for justice and reconciliation today is that in the history of our country, we have not always upheld foundational values such as the rule of law in relations to Indigenous peoples. And I have seen the negative impacts for freedom, equality, and a just society this can have firsthand. So when I pledged to serve Canadians as your Minister of Justice and Attorney General, I came to it with a deeply ingrained commitment to the rule of law and the importance of acting independently of partisan, political, and narrow interests in all matters. When we do not do that, I firmly believe and know we do worse as a society. I will conclude by saying this. I was taught to always be careful what you say because you cannot take it back. I was taught to always hold true to your core values and principles and to act with integrity. These are the teachings of my parents, my grandparents, and my community. I come from a long line of matriarchs, and I am a truth teller, in accordance with the laws and traditions of our big house. This is who I am, and this is who I always will be. Galakasla, thank you.
Thank you very much, Ms. Wilson-Raybould. I appreciate your patience on getting here today. It hasn't been an easy path, but I know that Canadians really appreciate it, and they appreciate your testimony today. And I just want to start off by saying that I believe every word that you said today. And I appreciate your honor, and I appreciate your honesty, and I appreciate your integrity and grit in coming forward in the way you have. So I do have some questions, though, and I'd be grateful for your input and your point of view. First and foremost, I'd like to know, the Prime Minister has said that you will be able to discuss all relevant information, but do you believe that there is relevant information that you are unable to include in your 30-minute statement that would be helpful for the committee?
Well, thank you for the comments and the question. As I said in my letter to the committee yesterday, as I said in my remarks today, the extent of the order in council and the waiver of privilege and confidentiality extends to January the 14th, when I was sworn in as the Minister of Veterans Affairs. So it does not include any conversations that occurred thereafter. It does not include conversations that I may or may not have had with the Prime Minister, and it does not include the conversation that I had with my former cabinet colleagues after my resignation from cabinet.
Do you think those would be relevant to our considerations?
Well, I believe that having heard some of the deliberations and questions asked by the committee over the course of the meetings that you've had, some of the questions would be answered if that information was made available.
One of the important pieces of your testimony today were the number of names that you provided for us, giving us a different list of characters that have been involved in this situation since it began in September. I'm wondering if you'd be so kind to provide us with a full list of those names. I've jotted down a few of them, but I don't have the complete listing. Would that be something you'd be willing to do for us?
I believe the full list of names is contained within the remarks that I think are being distributed, but if I counted incorrectly, I will provide all of the names.
I appreciate it. Just on page 14, you mentioned that there were various officials that came forward at the time. If you have any recollection of who the various officials were, that would be helpful for us in terms of making sure we have a complete list of all the witnesses. On January 7, you've pointed out to us that you were told that you were being removed as the Attorney General. As well, you posted a very lengthy Facebook post after your movement to the Minister of Veterans Affairs, but I would assume that you thought a lot about what you would include in a note like this during the time when you were actually Attorney General. And as such, I think and I believe that the statement that you made, even though it was on when you were Minister of Veterans Affairs, technically did come to light and was part of your thought process when you were Attorney General. I just wanted to ask you a couple questions about your Facebook post. The first one, and I quote, it's where, and you mentioned it in your remarks, it has always been my view that the Attorney General of Canada must be nonpartisan, more transparent, and in this respect, always willing to speak truth to power. Do you believe, for the record, that you were removed as the Attorney General because you spoke truth to power on the topic of the SNC ongoing prosecution?
Well, thank you for the question, and I am going to have to be very careful what I say.
I understand.
I believe that I am able to speak to my thought processes from January the 7th up to the time that I was sworn in as the Veterans Affairs Minister.
Yes.
I think it's apparent from my remarks that I was concerned that the reason why I was being shuffled out of the Minister of Justice and Attorney General possibly was because of a decision I would not take on SNC and the DPA. I raised those concerns with the Prime Minister and with Jerry Butts. And as I said in my remarks, those were denied. I cannot speak to anything that I thought about after that point.
I appreciate that. Second part of this letter, you say that the unique and independent aspects of the dual role of the Minister of Justice and the Attorney General of Canada are even more important. I know Canadians across the country expect such high standards to continue to be met, especially in the uncertain times in which we now live, and I expect this to continue. I'd like to know if you are concerned that it's possible that the independence of the Office of the Attorney General is being eroded now, given what you've told us in your testimony today, your understanding that the current Attorney General was to be briefed on the SNC-Lavalin deferment decision.
Well, thanks for the question, and I will not comment on the current Attorney General, but I will comment on when I was the Attorney General and the thoughts that I had when I was on vacation in Bali, and when I received a call from the Prime Minister. While I was the Attorney General through these 4 months, leaving aside all of the very inappropriate political pressure, interference, I was confident in my role as the Attorney General that I was the final decision maker on whether or not a directive would be introduced on the SNC matter. So I knew as long as I was the Attorney General, this would not occur. I had concerns that when I was removed as the Attorney General, that this potentially might not be the case. I decided that I would embrace this new role, a very important role, and I really want to say publicly that the role of Veterans Affairs is an incredibly important role, and I took it very seriously. But I had decided to take on the role requested of me by the Prime Minister, but I had concerns, and I knew that in my new role, still sitting around the cabinet table, if there had been a directive that was placed into the Gazette, I would have resigned immediately from cabinet.
Thank you very
Well
much.
done.
My set of questions, I want to kind of get a general sense of some timelines. I know you've laid it out here, but just in trying to keep up a little bit. Would you say, or is it fair to say that in and around, and if I have the wrong date, please correct me, September 17th, I think is when you first met with the Prime Minister, on which, where it wasn't, the purpose of the meeting wasn't at first for the SNC-Lavalin, but it was brought up. And is it fair to say, was it at that point that you felt the questions of your role on this matter, that you were uncomfortable at that point? Or would you say you were uncomfortable from the initial feedback that you heard that your Chief of Staff had been contacted by Mr. Chin? So let's kind of start there.
So there's a couple of questions in
Yeah.
there. If I don't answer them, please let me.
Yeah, no problem.
So the reason for I requested the September 17th meeting, as I said, on an important matter. As I said, the Prime Minister brought up SNC and the Deferred Prosecution Agreement. And with the clerk present, we had conversations about SNC. Well, he brought up SNC about jobs and the potential of job loss. And I will say, entirely appropriate conversations for the Prime Minister to bring up. What I will say is that the conversations turned to be completely inappropriate when there was discussion about the Quebec election, about the fact that the Prime Minister was a member of Parliament in Quebec. It was at that point that I immediately became concerned, and because I was the Attorney General, sought to have a conversation with the Prime Minister about the law, about the role of the Attorney General and the necessary independence that the Attorney General must have in exercising their discretion, in this case around a prosecution. The political concerns that were raised prompted me to ask the question of the Prime Minister directly if he was politically interfering with my role as the Attorney General. So at that point, my senses were heightened. The Prime Minister assured me that that was not the case. But soon thereafter, I instructed my staff and myself as well to ensure that we had a very detailed chronology of all meetings and conversations about SNC and deferred prosecution agreements.
Thank you. So you wouldn't say that it was a red flag necessarily on the topic or the conversations with Mr. Chin on September 7th, because it was those conversations about businesses. It was once the conversation in your mind changed to any politics. Or were you equally concerned on September 7th?
On the earlier meetings prior to the meeting with the Prime Minister, Ben Chin had conversations with my Chief of Staff. And again, in terms of public policy, in terms of having discussions about impacts of decisions and loss of jobs, that was appropriate.
Okay.
But I will say, in those calls, and I don't have my notes in front of me, but I have a pretty generous memory, Mr. Chin raised the Quebec election. And I will say, it's okay to talk about job losses. It's okay to talk about it in initial conversations. But when those topics continue to be brought up after there's a clear awareness that a decision has been made, it becomes inappropriate.
Thank you for clarifying. And sorry, I just want to clarify on that point, because you mentioned you have notes and a pretty good memory. But in the written submission or your verbal remarks, any conversations, at least from September 7th, 8th, I think 11th, at least involving Mr. Chin, were with your staff, not you directly. Did you leave out conversations that you also had, or was it just notes that you had from your conversations with somebody who had a conversation with Mr. Chin? I just want to clarify.
Yeah, sure. No, I'm happy to answer the question if you'd permit me just to speak about how ministers, at least my minister's office works. I have an incredibly close relationship, necessarily so, with my Chief of Staff. I also at that time had a very close relationship with my Judicial Affairs Advisor, who throughout some of this period of time was acting as my Chief of Staff, given that we were out of the country. Whenever my Chief of Staff has a conversation, she takes notes on the conversation and immediately relays the conversation to me, particularly in cases where there's concerns about the conversations that were had. So the close relationship and the necessary closeness of the relationship makes it that she and I are sharing important information and proceeding on the same basis with respect to the meetings, telephone calls, and emails that she would receive. It is her obligation, and it was my instructions for her to provide me with all of these details.
Thank you. And
Ms. O'Connell, your last question.
okay, perfect, thanks. And then it was in here, I'm sorry, I don't recall, but it did say somewhere in these conversations that either you or your staff related on behalf of you that you would be, in this at least September timeframe, open to having further conversations on the SNC-Lavalin matter. Is that not correct? Or in September you had felt comfortable and confident that the decision was made?
Well, during that time frame, I had commenced conversations and had asked for briefings, as I regularly did when I received a Section 13 notice. I think it's fair for me to say that there was a heightened awareness about this Section 13 notice that came in with respect to SNC. These conversations were all internal to the Department of Justice, and I was exercising with my Attorney General hat on what was appropriate for me to consider based on what I read in the Section 13 note from the director. We did not reach out externally. The Minister of Finance's office reached out to my department, and then these conversations began.
Thank you.
Thank you. Mr. Rankin.
I have to say that I am very shaken by what I've heard here today. I've been a lawyer for over 40 years. I've taught a generation of law students about the rule of law. And what I've heard today should make all Canadians extremely upset. Now, Ms. Wilson-Raybould, we're both from British Columbia. We've known each other for many years, and I need you to know that I believe you entirely. I need you to know that. And I want you to know as well that I very much admire your courage in being here and telling Canadians what you have experienced. Because I believe, if we believe you, which I do, that there is no other conclusion that one can reasonably draw, but that there was a sustained, consistent effort to interfere politically with the critical role that an Attorney General must play in our legal system. You have said, to quote back what you said, I experienced a consistent and sustained effort by many people within the government to seek to politically interfere in the exercise of prosecutorial discretion in my role as the Attorney General of Canada in an inappropriate effort to secure a deferred prosecution agreement. You talked of 10 phone calls, 10 meetings specifically about that. And then you talked about what I would call the consequences and threats if you didn't knuckle under. You said the potential for consequences and veiled threat if a deferred prosecution was not available to the SNC were brought to your attention during those conversations. So my question is this: how can Canadians, if they believe you, as I do, draw any other conclusion but that there was an attempt to politically interfere with your role as our independent Attorney General?
Well, thank you for the comments and the question, albeit I think the question is somewhat rhetorical. I sought in my testimony today to state facts, and in my testimony, I came to the conclusion, and throughout the 4 months, that there was a sustained effort, an attempt to politically interfere with my discretion as the Attorney General of Canada. It was inappropriate.
And on January the 11th, you said that the Friday before the cabinet shuffle, your former deputy minister was called by the clerk and told that the shuffle was happening, and that the deputy minister said one of the first conversations that the new minister will be expected to have with the prime minister would be on SNC-Lavalin. So it appears to a person, a reasonable person looking at that you were removed from your role because you would not change your mind, despite these persistent and consistent efforts to have you do so, and that because you didn't change your mind, you were fired from the role of Attorney General. That's what I take from the material. In other words, there appears to be a direct link from that conversation the day before the cabinet shuffle and what occurred, your removal from your role as Attorney General. That would appear to be what's said. Now, I have a question. After this, what you call consistent and sustained pressure to reverse your decision, I'd like you to tell us a little bit more why you did not change your mind.
I did not change my mind to enter into or to issue a directive to the Director of Public Prosecutions on the matter of putting out an invitation to negotiate a remediation agreement with SNC, because I had the benefit of reading the Section 13 note, of conducting my own due diligence around the appropriateness of entering into a deferred prosecution agreement with SNC. I had the benefit of feedback and briefings from my departmental officials as well as my political staff. I made my mind up prior to the September 17th meeting. And for those people that know me, my decision-making process takes into account many views, and I welcome many views on public policy issues. And having taken into account many diverse views, knowing confidently my role, my independent role as the Attorney General, and the need to make a decision. And I know you are studying the Shawcross principles, and I don't want to get into talking about the Shawcross principles, but as the Attorney General, you make decisions with your judicial hat on, leaving aside political considerations or otherwise. I had determined that I was not going to issue a directive. It was inappropriate to interfere with the discretion of the Director of Public Prosecutions, and having made up my mind, taking into account all of the information, again, for those who know me, I was not going to change my mind.
Thank you.
Thank you very much. Ms. O'Connell?
That if it wasn't a secret that those were your concerns, why not until December 5th did you communicate with Mr. Butts specifically about those communications? It was somewhat stated that you would be willing to, or someone in your office would look at the matter back in September. So if it was constant, and you acknowledge that you spoke to Mr. Butts on a regular basis, why not raise it earlier in September or October about those ongoing conversations with anyone in the PMO or other ministers' offices? Or did you, I guess is a fair point, did you communicate prior to that about those concerns?
I
with
appreciate the
Mr. Butts?
question and being able to clarify again the timeline. I absolutely communicated in September, not to Jerry Butts, but to the Prime Minister of the country, the concern that I had. I communicated to the clerk of the Privy Council, who, as everybody knows, is the Deputy Minister to the Prime Minister. I communicated to Elder Marquez and to Mathieu Bouchard. I communicated to the Deputy Minister of Justice and the Deputy Attorney General of Canada. And when the sustained efforts of political interference continued, I felt, and I have text messages when I requested the meeting with Jerry, that ultimately resulted on December the 5th, that it was time to reiterate my concerns to him about the inappropriate nature of these conversations, as I did to Minister Morneau in October, I believe, or September, I might be getting the dates wrong, about the inappropriateness and that they had to stop.
So then you didn't mention Ms. Telford. So is it fair to say you didn't speak with Ms. Telford, I guess, between those September dates? Or did you ever mention it to Ms. Telford about or have communications via text, emails, and writings that what you say were continued pressure?
Just to correct, it was September the 19th that I had the discussion with Minister Morneau. To your question, most of the conversations that I have with the Prime Minister's office at the highest level, either Katie or Jerry, would be with Jerry Butts.
Okay.
But to be clear, my Chief of Staff had direct conversations with Mr. Butts and Ms. Telford, as I described in detail on December the 18th.
So early, and then after September 19th, that meeting with the Prime Minister, did you speak to him again about the continued pressure that you felt?
The meeting I had with the Prime Minister was on September the 17th, and after September the 17th, I did not directly talk to the Prime Minister until January the 7th, but in between those dates, there were, as I described, numerous meetings with the Prime Minister's office senior staff, as well as the Clerk of the Privy Council.
And you mentioned earlier...
So I'd like to first go back to the September 17th meeting with the Prime Minister and the Clerk of the Privy Council. You mentioned that it was here where you had specifically asked the Prime Minister whether he was interfering, and his answer was that the decision was always yours. Is that correct?
That's not exactly what I said. I had raised the background about comments that were made by the Prime Minister and the clerk, and I know that that has been what has been reported in the media, but that's not what was said. I asked the Prime Minister a direct question after having comments around elections and being the member of Papineau. Are you interfering with my role as the Attorney General, my decision? And I advised him strongly not to do that. So it was my direct question to the Prime Minister.
And he said the decision was always yours, correct?
He did not say that. He said, no, no, no. That's not what I'm doing.
Okay, okay. So the main purpose for this meeting, what was the main purpose of the meeting?
I am not at liberty to discuss that as meetings and discussions between the Prime Minister and myself, other than what's covered in the waiver with respect to SNC and deferred prosecution agreements is covered by Cabinet confidence.
When the Clerk of the Privy Council testified here before committee, he had mentioned that the main purpose of that meeting was the Indigenous rights framework, and that SNC-Lavalin was a subject matter that was touched on briefly. Would you be able to say if that was correct or incorrect?
I will say that the Clerk of the Privy Council is at liberty to say whatever he wants. I have indicated that the meeting of September the 17th had to do with another extremely important matter, but that the Prime Minister raised the issue of SNC and deferred prosecution agreements at the outset of that meeting.
Okay. My next question is about the fact that you had mentioned the appropriateness or inappropriateness and where the line has kind of been drawn. You've indicated that when talking about jobs, the Prime Minister or the member from Papineau was completely in an appropriate space. But when you said he had spoken about the headquarters moving out of Montreal, that was inappropriate. Is that correct?
No, I didn't say that. I said that where, and I didn't say alarm bells, but where my alarm bells went off was when the Clerk of the Privy Council talked about the fact that there was a board meeting for SNC coming up on Thursday, September the 20th, that there was an election in Quebec, and then the Prime Minister interjected and said, I'm a member, or I'm an MP from Quebec, the member for Papineau. That is entirely political and entirely inappropriate, which gave rise to the question that I asked the Prime Minister.
On September 18th, I believe you,
This will be your last question.
okay, thank you. On September 19th, you had both met with the clerk and you had met with Minister Morneau in the House. In your discussion with Minister Morneau, I believe you had said that it's inappropriate and he should stop talking about it when he had talked about saving jobs. But in your discussion with the clerk on that same day, you had offered that if SNC-Lavalin were to send a letter to you expressing their concerns and their public interest arguments, you were open to looking at that letter. Is that correct?
That's not correct. I did.
It's here in your statement, opening statement.
If you allow me to answer, I can just clarify where that part wasn't correct. I had discussion with the Clerk of the Privy Council, recognizing the conversation that I had just the day before had with the Prime Minister, where he asked for solutions, recognizing I had already made my decision. I had indicated to the Clerk of the Privy Council that if SNC were to send a letter to me as the Attorney General expressing their concerns, their national interest concerns, their public interest concerns, that if I were to have received a letter, I would have immediately forwarded it on to the Director of Public Prosecutions. I would not have looked at it because it is entirely within the purview of the Director of Public Prosecutions, and any involvement I would have in that letter would be inappropriate. So what I said was I would immediately forward it on to the Director, not consider the letter.
Okay, thank you.
Thank you. Ms. Raitt.
Ms. Wilson-Raybould, when you speak to Jerry Butts or Katie Telford or the Clerk of the Privy Council, do you believe that they are speaking with the full authority of the Prime Minister in their discussions with you?
Yes.
I'm wondering some specific questions, if I may. Do you believe that the Prime Minister or anyone in the Prime Minister's office had any lawful authority to tell you to direct the Director of Public Prosecution on what to do?
No, I was the final, and as the Attorney General, is the final decision maker on whether or not, as the top prosecutor, to do anything with respect to a specific prosecution.
Yeah. Is it fair to say that, given your testimony and everything you've told us, that you suffered from repeated communications with you, either directly or indirectly, with the intent of changing your mind? It was repeated communications, directly or indirectly.
That's fair to say.
Okay. I'm wondering as well, given the number of times in the final part of your statement, Mr. Butts indicated to you in your conversation that you needed to find a solution to the issue. The clerk of the Privy Council, in the statement that you received, in the text that you received from your chief of staff, there's details about not wanting to debate legalities anymore. There's no solution that doesn't come from some interference. The clerk indicating that I think he, meaning the Prime Minister, is going to find a way to get it done one way or the other. You reference as well that it's the Prime Minister's prerogative to do what he wants. You said you were having thoughts of the Saturday night massacre. The clerk said he was worried about a collision between you and the Prime Minister. You mentioned a few minutes ago that you thought they were veiled threats. This all seems to me, if I may, that there was an intention from all of these comments and this continued pressure to make you fear for your job at the end of the day, that there would be a shuffle or that you would be removed from your position. Is that a fair assumption that I'm making?
Well, I'm not going to speak to the intention of other individuals.
Fair enough.
I will speak to the very heightened level of anxiety that I had that increased and culminated in my discussion with the clerk on December the 19th. And I remember distinctly ending that conversation with the clerk by saying, I am waiting for the other shoe to drop, which I believe that reflection or my comments can speak for themselves.
And I'm not trying to split a hair here, and I apologize if you take it that way and you can give me the same answer as you did on intention. But do you think the purpose of those comments were to cause you to have a second look at the issue because you were worried about whether or not you'd remain in cabinet?
Can you answer the question again?
I certainly can. Do you think the purpose of those comments that were thrown into your conversations, either with you, with your chief of staff, directly with the clerk, through Jerry Butts, through Katie Telford, or even the clerk indicating how anxious the Prime Minister was and you didn't want to be at loggerheads, do you think the purpose of those comments that they threw in their conversations was to put pressure on you and make you think about whether or not you would be remaining in cabinet?
I am confident that the purpose of those discussions, the December 18th and the December 19th discussions, were to put extraordinary pressure on me to change my mind.
Yeah.
As to the intention of the individuals that spoke to either my chief of staff or myself, I can't reflect on their intent.
Yeah, no, fair enough. I have. Okay, if I may, on January 7, you received your phone call that you were going to be moved in positions. I've had that phone call in the past as well, so I know what it's like. But I'm wondering if there was any conversation that you can tell us about in terms of who told you that you were going to be moved from Attorney General to Veterans Affairs, and if there's anything pertinent to SNC in that conversation.
Well, I did state, and this is within the order in council and the waiver that was provided me with respect to cabinet confidence, with respect to SNC and deferred prosecution agreements. I had a conversation with the Prime Minister on January the 7th, and he spoke to me about my being shuffled out as Minister of Justice and Attorney General, provided rationale of which I won't get into. And then I said to him, I can't help but think that this has something to do with a decision I would not take. I had a subsequent, very close in time conversation with Jerry Butts where I specifically said, I know this has to do with SNC and a decision that I wouldn't take. To which he said, "Are you questioning the integrity of the Prime Minister?" To which I didn't say anything.
Now, I understand in your remarks, you were suggesting that some people were approaching you and asking that you obtain legal counsel. Would it be fair to say, as a routine matter of work, that your department does receive legal advice from various firms?
I'm sorry, could you clarify what
Yes.
you meant by people were approaching me to obtain legal counsel in what context?
Yes, I understand that you referred that there was one discussion with Mr. Bouchard, and he asked you whether you would consider the option of seeking an external legal opinion.
So in the context of deferred prosecution agreements and SNC, yes, I had that conversation with Mathieu Bouchard, Elder Marquez, and a number of other individuals. At that time, all of those individuals knew that I was firm on my decision not to interfere with the discretion of the Director of Public Prosecutions, and having conversations about hiring external legal counsels in that environment is entirely inappropriate.
But you've worked on some very difficult files during the period you were serving as Minister of Justice and Attorney General. Would it be fair to say that routinely you would ask for outside counsel just to have a better understanding of various pieces of legislation?
In my role as the Minister of Justice, and having had the opportunity, as people here know, coming before this committee on various pieces of legislation, we would engage with external counsel. But let me be clear. My role as the Minister of Justice, shepherding legislation through the House of Commons, is entirely separate from my role as the Attorney General. Where suggestions of obtaining external legal counsel after I had made my decision as the Attorney General on this matter, that was entirely inappropriate.
Raybould, first of all, having heard it all, I have to ask you the question. Going from being your first appointment and going through the last 4 months, and although having comfort going into Veterans Affairs, which is a wonderful portfolio, and I agree with you fully that you served there. How did you feel at the end of this? Like, what's the emotion that you felt out of all of it? I mean, you're giving us wonderful facts, but surely there must be some level of disappointment or sadness out of how everything has unfurled.
Generally, or with respect to being moved as minister?
No, in general, how you've been treated.
I have serious concerns about how things are reported. I have concerns about what people generally call smear campaigns. It makes me very sad when, and this isn't about me personally, it's about the work that I was able to do with an extraordinary group of people when I was the Minister of Justice and the Attorney General, being impugned publicly, recognizing the commitment that my public servants then, and I know to this day, have to ensuring justice in the country and moving forward with legislation, as well as my political staff. So how do I feel? How did I feel? I have to say that I loved being the Minister of Justice and the Attorney General. I can't imagine any lawyer not loving being the Minister of Justice and the Attorney General. And I believe that I served in that role with hard work and with integrity. And I'm proud of the legacy that we left. So I don't want to make anybody think that I wasn't sad when I was shuffled out of that role. Of course I was. But I understand that it's the prerogative of the Prime Minister to make those shuffles. And how I conduct myself is to embrace other opportunities, which I sought to do in the unfortunate limited time that I was the Minister of Veterans Affairs.
Thank you. And my colleague, Pierre Paulus.
Merci. Oui, merci.
Thank you, Mr. Chairman. Ms. Wilson-Raybould, the Minister of National Revenue, Ms. Laboutier, mentioned that this question was raised during a cabinet meeting. In his testimony, Mr. Wernick said it's never been discussed in cabinet. You can't have two different versions. I don't want the details. I just want to know which of these two people is right, Ms. Laboutier or Mr. Wernick.
Well, I'm not going to comment on which of those two people were right, but what I can tell you is what I know, recognizing that I'm able to speak about SNC and deferred prosecution agreements. We had discussions at Cabinet about creating a new tool for prosecutors, remediation agreements. There were conversations, but not central to the conversations. There were peripheral comments about SNC, but it was not the heart of our discussions. Our discussions were about creating the tool for prosecutors.
Okay, merci.
On February 12th, Madam Wilson-Raybould, the Prime Minister said this, quote, "If anyone felt differently, they had an obligation to raise that with me. No one, including yourself, did that," close quote. But you've testified that you met the Prime Minister on September 17th. You've testified that on December the 5th, Jerry Butts and you got together, and you've told us that he speaks with the full authority of the Prime Minister. On December the 18th, your Chief of Staff had a meeting with Mr. Butts and Ms. Telford. So isn't that at the very least a misleading statement by the Prime Minister? You did speak with him. Your people spoke with him. You spoke with his people. Isn't it, in fact, misleading to say you did not do that?
Well, again, I'm not going to speak directly to comments that the Prime Minister made. I believe that the chronology and the facts that I presented here before the committee and the testimony that I've given speaks for itself.
Okay. I'd like your comments on something that was referred to earlier. In your testimony, you said on December the 19th, you had a call with the clerk of the Privy Council office, Mr. Wernick, who testified here before. And referring to the Prime Minister, the clerk said this, quote, your words, "He's going to find a way to get it done one way or the other. So he is in that kind of mood, and I wanted you to be aware of that." What do you understand by those comments?
Well, as I said, I had, during this conversation with the clerk, I had a heightened level of anxiety. Again, this was the culmination of many meetings and telephone calls with either myself or my Chief of Staff that continued to escalate. This was the top of that escalation. And I said, there were 3 times in this conversation where I felt that the clerk invoking the Prime Minister's name was acting in a threatening manner.
Mm-hmm. Do I have another? All right. You've told us, and the Order in Council precludes us from talking about things after January 14th. Apparently that's the rules. We can't talk about that. But on February the 18th, Jerry Butts, the senior advisor to the Prime Minister, resigned. We had all these meetings about SNC-Lavalin. In his letter of resignation, he referred specifically to you. Do you know why?
I have absolutely no knowledge other than what everybody has read in the statement by Jerry Butts, why he resigned, if there was any other reason.
Given the testimony that you provided for us today, Ms. Wilson-Raybould, I have to ask the question about whether or not you were approached by the Prime Minister, the Prime Minister's office, the Clerk of the Privy Council, and given any directions, directives, or suggestions on the conduct of the Mark Norman trial or any other trial that was within your bailiwick as the Attorney General?
I'm not at liberty due to confidences to discuss any matters beyond SNC and deferred prosecution agreements.
Thank you. And for clarity, can you tell us what you discussed with the Prime Minister at your meetings in Vancouver on February 11th?
I cannot.
And can you tell us why you've resigned from Cabinet?
I cannot.
And can you tell us what was discussed with the Cabinet on February 19th?
I cannot.
If the issues surrounding your ability to communicate these conversations to this committee were in fact resolved and you were able to be released from cabinet confidence or from privilege, would you be willing to return to this committee and give us testimony again?
I would be.
I'm wondering as well, Ms. Wilson-Raybould, that when the clerk was speaking with you in those communications, I know I've asked you already, but I want to just be crystal clear that when the clerk was speaking with you, he was speaking with the full weight and the authority of the Prime Minister, and it was your understanding that the Prime Minister was speaking through the clerk to you.
I can only go by what the clerk said to me in those conversations. In that conversation where he invoked the Prime Minister in terms of relaying messages from the Prime Minister.
Okay. And if I may clarify, in your statement, you have delineated these for us in terms of going through what the things that the clerk was saying on behalf of the Prime Minister. It's contained in your statement before us today.
That's correct.
Okay. A couple of times you have mentioned about your January 7 phone call with the Prime Minister about not going to be the Attorney General any longer. And you've indicated a couple times that you didn't want to talk about what the contents of the conversation were. I respect that. I'm not going to ask you a third time. Can you tell us why? Under what authority are you saying that you don't want to disclose the conversation, just so that I can understand whether or not you were bound by something else, so that we can perhaps take that roadblock out of the way to get your full testimony?
Well, I'm not going to provide legal advice to the committee, but I am going by the order in council and the waiver that was provided around SNC and deferred prosecution agreements, and any conversations around those topics when I was the Attorney General I am able to speak about.
Your Chief of Staff, her name is Jessica Prince, correct?
That's correct.
Was
former
she,
Chief of Staff.
I'm sorry, my apologies, correct. Your former chief, I understand fully the relationship between Chief of Staff and Minister, and it was pretty awesome that she decided to move with you to Veterans Affairs, just saying, it's very nice.
I thought it was totally awesome.
Yeah, very awesome. What I would like to know, though, is in her conversations with Ms. Telford and Mr. Butts, did she indicate to you, and I know it's hearsay, but you do have testimony talking about her text to you, did she have fear about whether or not she would still have a job as a Chief of Staff if she didn't convince you to review the decision on interfering with the trial that was ongoing?
I, of course, don't want to speak for Jessica on this, about the specific question on fear.
Yeah.
I can say that in my conversations with her and in my text messages, but particularly in my conversations with her after that, she was quite upset after the meeting. And I will say now that I have this opportunity, and I think some people are watching, to Jessica Prince, who was my Chief of Staff at the Department of Justice and came with me to Veterans Affairs. She is an extraordinary human being and an extraordinary lawyer.
Incredibly well educated and very professional in everything she does. I would agree with you on that, and I think everyone will appreciate that you give kind thoughts to your Chief of Staff. That's always extremely nice. One last thing, if I may. Can you remind us that, well, it's my understanding, and it was in the case when we served, that Chiefs of Staff are hired and fired essentially by the Prime Minister's office at the end of the day? It'd be difficult for you as a minister to retain a Chief of Staff that was not in favor with the Prime Minister's office. Is that true in your case?
I'm not going to comment on the interactions between my office and the Prime Minister's office.
Okay, thank you. Thank you.
Very much, Ms. Raitt. Ms. Khaled.
I've always felt that you've been a very vocal advocate on issues that you genuinely believe in, without regard to other viewpoints. You've been vocal at cabinet. You've been vocal to the Prime Minister. You've been vocal to Canadians. In fact, you've gone on the record at many public events, and you've really expressed your viewpoints on issues that you genuinely believe in, such as the Indigenous file. And I just going through your testimony and your chain of events, I see that there hasn't been communication between you and the Prime Minister himself from September up until the time when he called you for the shuffle. Why is that? Why didn't you speak out to the Prime Minister when you've been so vocal on issues such as the Indigenous file, and you know that you have the access? Why did you not speak out to him when you had these concerns? And do you feel that you had an obligation to do so?
Well, I need to say a couple of things with respect to your question. I completely reject your characterization of that I do not have regard for other people's opinions. And you talked about the cabinet table. And with respect, you would have no ability to know about discussions around the cabinet table. I don't apologize for being vocal with my opinions. That doesn't mean to say that I don't value other people's opinions, because for the entirety of my professional career and how I was raised, in terms of consensus-based decision-making, it is incredibly important to take into account the views of other people. That's how we make good public policy in this country. You talk about Indigenous issues. I'm a proud Indigenous person from the west coast of British Columbia, and I will not apologize for being a strong advocate pursuing transformative change for Indigenous peoples in this country. I have worked in the Indigenous world as a politician for a significant amount of time and have a very in-depth understanding of the issues that Indigenous peoples face. That's not to say everybody agrees.
Ms. Wilson-Raybould.
And I appreciate to hear other people's opinions. And to your question with respect to the Prime Minister, I believe I've covered that ground. I had a direct conversation with the Prime Minister, as I had direct conversations with the people in his office and the Clerk of the Privy Council.
Please excuse me, Ms. Wilson-Raybould. I was referring to your vocal advocacy as a sign of strength. You know, as a member of Parliament and your colleague, having worked with you, I acknowledge your effectiveness in advocating for the issues that you genuinely believe in, and we appreciate that. Thank you for your service. I do want to just understand here. You mentioned the political interference being cited as the Quebec election. And the Quebec election was over at the beginning of October. So if you can please help Canadians understand, from October to December, what was the context of the inappropriate pressure? Sure.
Yes, the Quebec election was something that was brought up on the September the 17th meeting. There were many other inappropriate conversations and attempts at political interference that occurred after that date. An example, which I've already talked about, was after I had made my decision as the Attorney General, which is entirely within my discretion to make. There were repeated attempts by people in the Prime Minister's office to get me to hire external legal counsel to evaluate my decision. There were further conversations about the election coming up, and if SNC were to move, this would be detrimental to the election. I further said that when we're talking about jobs and job losses, and of course I don't think there's anybody around this table that doesn't want to prevent job losses, that it was appropriate in the initial phases. But after I had made my decision as the Attorney General not to enter into or issue a directive, the successive and sustained comments around jobs became inappropriate because I had made my decision and everybody was fully aware that I had made my decision. I believe where it got even more heightened were what I described as the veiled threats that came towards the latter part of this time frame around December the 18th and December the 19th. There were many different occasions where the appropriateness line was crossed.
So just to clarify, thank you. Just to clarify, Ms. Wilson-Raybould, all right. So from after the Quebec election up until the end of December, as per what you've just said, are you stating, and I'm just seeking clarity here, are you saying that it was inappropriate because you had expressed that your mind had already been made on this issue?
My decision not to issue a directive had occurred prior to the September 17th meeting. The Quebec election, any partisan considerations before or after are entirely inappropriate, not relevant to me at the time wearing my judicial hat as the Attorney General in terms of considerations about whether or not I was going to exercise my discretion and issue a directive.
Thank you very much.
Thank you.
Mr.
You were, in referring to your conversation with Mr. Wernick, the top public servant in the country, the clerk of the Privy Council, in an answer to a question, you said something about waiting for the other shoe to drop. What did you mean by that?
Well, as I said before in questions, this was a very tense conversation. I had a high level of anxiety. This was the combination, or the culmination rather, of many phone calls and face-to-face meetings. What I meant by I was waiting for the other shoe to drop, at the end of the conversation, that's how we closed out our telephone call, was that I was under the understanding, based on what the clerk had told me, that he was going back to talk to the Prime Minister before he left, recognizing what he had also told me, that the Prime Minister was dug in, that he was firm, that it's not a good space to have an Attorney General at loggerheads with the Prime Minister. I had a heightened level of anxiety that I would be getting either a call from the Prime Minister the next day, which the clerk indicated might happen, and that there may be further direction or another outcome for me as the Minister of Justice and Attorney General.
In other words, consequences for you doing your job as an independent AG and saying you'd made your decision up, that was it. It could be consequences, is what you inferred from that conversation.
That is a fair assessment of how I interpreted the conversation.
Now, you've told us about a lot of officials in the Prime Minister's office, a senior clerk of the Privy Council. Do you not think that Canadians, because we're doing our job for Canadians to get to the bottom of this, that we would have a better understanding of the situation if we heard from the officials that you've referred to?
Well, I can't speak to whether or not you have a better understanding. I believe that it is important to hear from as many individuals that have direct connections or interactions in this case, which is why I don't know if pleased is the word, but I'm fine to be here and having this conversation because I know that it is important for me to put the facts before this committee for your consideration.
Thank you. You said, wrote something very interesting in your remarks, and I'd like to read it to you. You said, the history of Crown Indigenous relations in this country includes a history of the rule of law not being respected. Did this, in your history, your experience that you've referred to, did this inform or strengthen your resistance to any potential perversion of the rule of law, that history to which you referred?
My lived experience is incredibly important for my background, my upbringing, how I think about the world. It's that lived experience, not only as a professional, but being rooted in my Kwakwaka'wakw culture and the values that I was taught by my father and mother and my grandmother, that brought me to my role as the Minister of Justice and Attorney General of Canada. And I believed, and I still believe today, that it is incredibly important to have a diversity of perspectives and background, and to have a country, and we live in the greatest country in the world, that respects every individual with a recognition of the need for equality, of the need for justice, and in the case of Indigenous peoples, that we continue to work hard to create the space for Indigenous peoples to find their place and see themselves in the mirror of our Constitution.
Well, I understand that my time is almost at an end, and I just want to sincerely thank you. I want to thank you because you've presented a list of facts that I believe a reasonable person listening to this, and believing you as I do, would have to conclude demonstrate a sustained pattern of political pressure and interference with the independent role that you swore an oath to fulfill. And I cannot but think that we have more work to do as a result of your testimony. So I thank you sincerely, not just on my behalf, not just on our behalf, but on behalf of Canada, for your courage in being here and telling us what happened. Thank you.
Next we go to Mr. Bossino. Mr. Bossino.
Thank you very much, Mr. Chair and Ms. Wilson-Raybould. I really appreciate that you're here today. You and I have worked on a number of files together on a number of projects, and so I want to acknowledge your land acknowledgement as well. And if I were back in Treaty 6 territory, might say something like Mio Tatakwin Tatawa, which is Cree for guests, you're welcome, there's room here. So I appreciate what you've done. And that reconciliation and reconciliation with Indigenous peoples is all of our responsibility and the responsibility of all Canadians. I just want to ask a question because we all have our different ways of working, and I think it's known to people who've worked with you that you're a texter, and so I just want to know
I'm a what? Sorry?
You like texts. You communicate well by texting. And did you ever express any concerns to Jerry Butts in writing via text message when you were Attorney General? Were there any concerns expressed to him at all about this matter?
I would have to check, but I can't think of one off the top of my head.
Okay. Did you ever speak or write with Miss Katie Telford at all about the issue of SNC-Lavalin or other issues while you were AG?
Yes.
Did you ever speak about the issue of SNC-Lavalin, particularly with Miss Telford?
Not that I recall.
Thank you very much. Now, you see the Prime Minister regularly. You're in the House daily, there are cabinet meetings, there are committee meetings, cabinet room, caucus, other meetings, other events. You've talked about the September 17th meeting, and I have your document here, and I appreciate that you've provided a written document for us here. That meeting was with the clerk and the Prime Minister. My question for you is this: as Attorney General, and given all of the interactions that you detailed on that morning that played out over the course that you detailed with us this afternoon, everything that played out over September, October, November, and December, including the meeting with Ms. Prince, did you not have an obligation to raise these concerns with the Prime Minister, to call him or write him or stick up for your personnel or indicate that you felt that inappropriate pressure was being applied?
So I did raise the inappropriateness of the conversations. I raised it with many individuals within the Prime Minister's office. I raised it with the Prime Minister on January the 7th. Let me say this. And again, I am confident and know my role as the Attorney General, and I know and understand that I am the final decision maker on this. When faced with sustained pressure from, or attempts at interference from September the 17th up to and including December the 19th, by the Prime Minister's office, by the Clerk of the Privy Council, by the Clerk of the Privy Council invoking the Prime Minister's name, I had concerns. Well, I had beyond concerns. Why would I go to the Prime Minister to raise these concerns when I knew for certain that the DPA with SNC would not occur because I am the final decision maker? And
I'll get back to that issue of final
in the
decision
Prime
making.
Minister's office that were putting pressure on me to change that, included by virtue of the conversation with the clerk, the Prime Minister.
So I appreciate that. January 14th, you accepted a new appointment to cabinet as the Minister of Veterans. And you know what it's like in caucus. There are people, people run, they want to be MPs, and people want to serve around the big table. And that's part of being in this role. And it's a great honor to serve as a minister in any portfolio. And I can't imagine the great honor that it would be to serve the people who've served this country and who now live after having served. And so after you reaffirmed, on that day, accepting that position, you reaffirmed your confidence in the government. Is that the case?
I was incredibly honored to be the Minister of Veterans Affairs. It was a very different position from the one I had, but I embraced it, and I had a lot of considerations to make on a personal level over the time of Christmas and into the new year. And I'm getting to answer your question. I had serious concerns, as I said, that if I was no longer the Attorney General, that there would be a deferred prosecution agreement entered into and that it would be posted in the Gazette. As I said, I would have resigned from cabinet at that time. I decided, a very conscious decision, to take on the role that the Prime Minister offered me, and yes, it is an incredible honor. I don't want anybody to misconstrue that. I decided that I would take the Prime Minister at his word. I trusted him. I had confidence in him. And so I decided to continue on around the cabinet table with the concerns that I had around SNC because I took the Prime Minister at his word.
Thank you. So that oath that you took today, that oath that you took on January 14th, reaffirmed your confidence in the government. Do you have confidence in the Prime Minister today?
I'll say this, and I'm not going to get into any conversations about why I resigned. I resigned, other than to say this, I resigned from cabinet because I did not have confidence to sit around the table, the cabinet table. That's why I resigned.
And my question wouldn't be why you did resign. My question would be, why didn't you resign before?
Folks,